होठों पे सच्चाई रहती है, जहाँ दिल में सफाई रहती है। हम उस देश के वासी हैं जिस देश में गंगा बहती है। आज के इस गणतंत्र दिवस पर आपको हार्दिक हार्दिक शुभकामनाएं। सोसाइटी मित्र के तीसरे एपिसोड में आपका स्वागत है। मैं संजय चतुर्वेदी, आपका होस्ट। आज दो ऐसे इम्पॉर्टेंट जजमेंट्स लेके आया हूँ जिसमें ऑफ कोर्स डायरेक्टली और इनडायरेक्टली इट इज़ कनेक्टेड विद द रीडेवलपमेंट ऑफ द सोसाइटी एंड अदर एस्पेक्ट्स। बट दो बहुत इम्पॉर्टेंट जजमेंट्स ये हैं। पहला है कि यदि आपने पावर ऑफ अटर्नी कैंसिल की है, जब भी आप टर्मिनेट करते हैं किसी को, तो क्या आपकी लाइबिलिटी यथास्थिति बनी रहती है, और क्या आपकी जो लाइबिलिटीज़ हैं वो onus is on you to adhere to the power of attorney during the then there were their active power of attorney. Secondly, the deemed conveyance, when there is an deemed conveyance given, then will the unauthorized construction will be legalized. Now this is very important because this is the base for the redevelopment of a society. First thing first, let us now understand that the Honorable Bombay High Court, in the matter of ALJ, I'll just read from few lines from the judgments, and there's very important judgments as far as the society redevelopment is concerned, that the Honorable Bombay High Court, in the matter of ALJ Residency Cooperative Housing Society versus the state of Maharashtra and others, they the Honorable Court on 25th November 2024 have put a very specific rule that any deemed conveyance given under section 11 subsection 3 of the MOFA cannot be the unauthorized construction cannot be authorized. So when the society usually are going ahead with the redevelopment and then negotiating with the developer, saying that since we have received the deemed conveyance, even the DDR who has given the a deemed conveyance to the society cannot regularize the unauthorized part of the constructed. So usually what people do is that they say that since the deemed conveyance we have received, and it is now that the conveyance is received, so the whatever we are occupying any area, you have to give us as a rehab component, and further whatever percentage of the fungible FSI which the society could negotiate. Honorable Bombay High Court, I'll just read from few lines from the judgment itself. By this petition filed by under, it is a writ petition, the order dated so and so passed by the competent authority, District Deputy Registrar Cooperative Society Mumbai, application number so and so, under section 11 subsection 3 of Maharashtra Ownership and Flat Act, MOFA, dismissed the application is asserted. The brief fact was that the society had constructed some unauthorized, because maybe sometimes we enclose balconies, we enclose something, and then we make some structural changes, and because of that the society had substantially amended the past plan, and then the occupant have over the years have made some unauthorized constructions. Now that was the gist of the judgment. Now the fact, and the judgment very specifically have identified that even though there is a deemed conveyance given under section 11(3), then also the unauthorized part cannot be regularized. Now I will read just one or two para for your perusal, so that the things will be clear. Honorable Bombay High Court has on 24 pages judgment. It's a very landmark judgment, and the question was that what the competent authority have rejected the application broadly on the following findings: that the PAAA has been annexed instead of MOFA agreement, The architect certificate notes that by an order of so and so, the planning authority has proposed demolition of floor 6th and 7th floor. That is it was illegal floors. The sanction plan refers to only 3 CTS number, whereas the application refers to 5 CTS number, and the applicant have not produced the commencement certificate and occupancy certificate. Now, I'll come on occupancy certificate because recently some other rulings have come of the Honorable Bombay High Court. But what the Honorable Court have actually, found out in the matter was that it says that in para 18, even if it is accepted that PAAA does not set out the relevant clauses, the statutory provision of MOFA makes it incumbent to include in a MOFA agreement the particulars set out in section 4 of MOFA, and the agreement is required to be prescribed in form 5. The explanatory note to the model form 5 sets out the certain clauses of the model agreement which are statutory and mandatory and shall be retained in every agreement, and that is some clauses are being referred in the agreement. Now, what the honorable court have opined is, the honorable court said that I am unable to subscribe to the contention of Mr. Tripathi that grant of deemed conveyance will amount to legalizing unauthorized construction. Acceptance of such submissions will place the cooperative societies in a predicament where the cooperative housing society, though willing to cure the illegalities and irregularities committed by the promoter, will not be able to do so by reason of absence of ownership rights. It is settled that an application for regulation can be filed only by the owner of the structure, and without grant of deemed conveyance, the status of the cooperative society would bar them even from applying for regularization or from proceeding with the redevelopment. Now, this is basically a ruling, and which is absolutely clear that Honorable Bombay High Court said that unless you are the owner of the land, you cannot apply to the regularization of the unauthorized structure. And if the deemed conveyance is given, that is not a blanket permission for you to that it is been regularized. That is a judgment number one. Today I was citing. Let's go to the Supreme Court. Honorable Supreme Court have Honorable Supreme Court have now in a landmark judgment, I'll tell you, is in the matter of Akshay and others versus Aditya and others. Now this judgment was basically when the society has and various others forums, it has escalated to NCRDC, and the NCRDC have said that since the society has given a power of attorney, I'll just read some facts of the case for you. That the appellant herein are the owners of the land in question. They entered into a joint venture agreement with respondent number 2, Gladstone, whatever, for the development of the land and for construction of flats are mentioned herein. It appears that the appellant also executed irrevocable power of attorney dated so and so, that is 2013, in favor of the respondent number 2 with regard to the said land. The respondent number 2, on the basis of the said document, entered into the sale agreements with the respondents, complainants for the units in question. So, basically, third party rights were created into the this, and then uh, the honorable court have very specifically, I'll just read some few lines from the judgment itself. Submissions made by the, I'm just not going into the detail. I'm just reading the opinion of the honorable Supreme Court. It says that Having regard to the submission made by the learned senior counsel for the parties and to the impugn or judgments and order passed by the state commission as well as the NCRDC, it clearly transpires that undisputedly an irrevocable power of attorney dated so and so was executed by the appellant in favor of the respondent number 2 along with the general joint venture agreement and of the same date, pursuant to which the respondent number 2 had undertaken to develop the land in question. It further appears that though alleged the said power of attorney was revoked by the appellant white dated letter dated so and so, the joint agreement has not been revoked so far, and the same still continues to be in force. As rightly submitted by the learned counsel for the respondent in the letter dated so and so, the appellant had stated to be not liable henceforth. After the said letter was sent, I'm saying letter, the appellant therefore were bound by the act deed of the respondent number 2 carried out pursuant to the irrevocable power of attorney till it was terminated in accordance with the law. It is also not denied that the appellant have not taken any action whatsoever against the respondent number 2 with regard to the alleged non-compliance of the terms and conditions of the joint agreement by the said respondent. Under the circumstances, it does not lie in the mouth of the appellant to say that the appellants are not liable for the acts of the respondent number 2. The NCRC, having considered all the issues with regard to the joint liability of the appellant as well as the respondent number 2, we do not find any good ground to interfere in the same. In the view of the matter, the appeal being devoid of merits and are dismissed. So basically, it is a a very clear landmark judgment on this, that even though the power of attorney was cancelled, you need to first terminate the agreement. The power of attorney, maybe the irrevocable power of attorney, the liability and the onus is on the society. See, I tell you, this particular subject which we are going to, and we have researched very well on the how to terminate a development agreement, rights and duties of the members and the society, rights and duty of the incoming developer, rights and duty of the elsewhere developer or outgoing developers. What are those rights and liabilities of the, to just uh, you know reduce the litigation between society, the new incoming developer and the outgoing developer. We have researched a lot of landmark judgments on this. We have in the today's episode taken these two landmark judgments just because to just make the legal standy understanding between the parties. Maybe it is a developer, maybe it's a society, maybe it's the incoming developer. Termination of a development agreement is not so very easy. It needs a lot of persuasion, legal rulings, judgments, other things. So next time when we meet again, I'm going to cite some very landmark judgments on the termination of the development agreement as far as this, and then when there's too much time is been taken by the developer, and then maybe there are so many other grounds where the termination happens, and then people don't understand that the legal documents cannot be terminated by verbal or letter or like that. It needs to have some decree, court indulgence, arbitrations, or maybe some other considerations. So with that, I will come again on the issue of termination of the development agreement. Today I am once again giving you the आज के गणतंत्र दिवस की बहुत सारी शुभकामनाएं. यदि आपको एपिसोड में और भी कुछ इम्प्रूवमेंट्स चाहिए, या आप कोई ऐसा सब्जेक्ट चाहते हैं या विषय चाहते हैं जिसपे कि लैंडमार्क जजमेंट्स को साइट किया जाए, आप ज़रूर आज के इस चैट बॉक्स में डालें या हमें लिखें editor@subticular.com पर, तो जिसमें कि वी विल सेंड यू द reply also, and we will also try to cover those subjects in our upcoming episodes. Till then, Jai Hind.